Hello, my name is Julieann Campbell and welcome to another one of the Museum of Free Derry's commemoration events 2021. So this is an event between the Museum of Free Derry and the Pat Finucane Centre, and the event is called Pulling a Fast One, the British Government and the Legacy of the Troubles. My name is Julieann Campbell and I'll be your chair, and I'm an author and I've been working with some families affected by the past, and that's why I'm interested in this subject. My guests today are three authors and academics behind a report released in April last year entitled Prosecutions, Imprisonment and the Stormont House Agreement, a critical analysis of proposals on dealing with the past in Northern Ireland. So with me today, I have Professor Kieran McEvoy from Queen's Uni. Hello, Kieran.
Hi.
Professor Louise Mallinder from Queen's Uni. Hello, Louise.
Hi, Julieann.
And Daniel Holder, the Deputy Director of the CAJ, which is the Committee on the Administration of Justice in Belfast. Hi, Daniel. Thank you all for joining us today. First question, we may as well refer back to the title of the talk. Are they pulling a fast one? What are your thoughts on that? Let's start with Kieran. What do you think of that?
I think I wouldn't overestimate the amount of strategy that goes into the British government's approach to legacy. I think that at times they have been making it up as they go along, and I don't see a clear strategy here. As some viewers and listeners will be aware, in 2014 the British and Irish governments and the 5 local political parties signed up to an agreement to deal with the past, the Stormont House Agreement. And in that agreement, there were 4 mechanisms agreed to do different things, basically, in terms of dealing with the legacy of the conflict. So it's a complicated architecture, but that's what the local parties and the 2 governments agreed. And basically, that we are now 7 years on, and that is yet to be implemented. An agreement that was made 7 years ago has yet to be implemented I mean, it's primarily for foot dragging reasons on the part of the British government. And they recommitted when the devolution of when Stormont was re-established in January last year. The British government recommitted to setting up those mechanisms within 100 days. And then instead of that happening, we had one Secretary of State who was sacked by Boris Johnson. A new Secretary of State came in, and then in March of last year he said that they were moving away from the Stormont House Agreement and adhering to the principles of the Stormont House Agreement, whatever that means. And so it appears to me that they are kind of making it up as they go along. I don't know how my colleagues feel about it, but I don't see a huge amount of strategy here other than the strategy of foot dragging.
What's your thoughts on that, Louise?
Well, I agree with everything Kieran said, but I think we also have to bear in mind that governments are rarely monoliths. Within the Conservative Party, within the relationship between the legislature and the executive, there are lots of different tensions and voices, and even between government departments as well. And I interpret the idea of pulling a fast one as either perhaps trying to engage in some sort of reneging on commitments or stalling or those sorts of things. And I think it's clear that there are some voices who are among the MPs or different parts of the media who are keen to do that. You know, they say it publicly, so we know that there are those advocates of that position, but there are a number of other voices within government as well. And so I think, as Kieran says, there's no grand strategy. It's like a multiplicity of competing views, and often it seems like the government's changing position because whoever's voice is dominant at a particular moment in time. So I think it's hard to see one kind of unified position on it.
And there's no consistency really on the leadership either, and that you're never going to get anywhere if it keeps changing. Daniel, what's your thinking on this?
Yeah, I mean, I agree with all of that. What I would add, though, is what is very consistent and has been consistent for a long sort of relentless attempts not to deal with the past, not to investigate particularly the actions of the security forces, and to resist and obstruct any legacy mechanism that gets set up. So I mean, we have a whole afternoon to go through everything. Take the example of Pat Finucane, the Finucane case. I mean, the British government and an international agreement committed to a full public inquiry. What did they do almost immediately afterwards? Well, rush through legislation to change the entire basis on which a public inquiry could be held so that ministers could interfere and obstruct the inquiry. at virtually every stage. I mean, I could go through hundreds of examples of that being the case. And what's happened since the Stormont House Agreement's a fairly good example of that. So end of 2014, you have an agreement, then the foot dragging begins. But not only that, what initially derails the process is the UK and government's insistence on inserting what was called a national security veto within the agreement. That the words national security were never mentioned in the Stormont House Agreement. And what that meant in practice, because that sounds like a very abstract term, but what that was really about was it was a power for British government ministers to be able to redact and censor the reports that would go to victims' families after an investigation on one particular ground, which was, it sounded like a very open-ended ground of national security. But in reality, it became very clear, particularly when you saw the draft legislation, that what they were doing was trying to conceal the involvement of agents of the state in killings so that they could remove that information and it would not be known to victims' families. So that was the initial problem. And then we had regular and repeated commitments from the government, from the British government, both to the international community within Europe, European Court of Human Rights implementation, things like that, and domestically that it would implement the Stormont House Agreement. And then one day, which was March of last year, exactly the same day as they introduced a bill called the Overseas Operations Bill, which grants sort of immunity for war crimes, for actions of the British military abroad. There was a complete U-turn on what had been agreed within the Stormont House Agreement. Instead, a very, very vague statement was made that there would be a rethink, that there would be a policy that didn't really involve discharging what are legal duties to investigate what went on in the past, and instead there'd be some sort of process. And we've really had no further details since as to what that'll be.
Was that Brandon Lewis in March last year when essentially just rejected all the and that, I think that came after a family consultation on what was contained in the Stormont House Agreement, am I right?
Yeah, it did. There was 17,000 responses.
Yeah, because I helped some families work on their responses, and it took a lot out of people, and I think it's very difficult and often re-traumatizing for people to engage like that. And then I remember the frustration when people were just told that essentially, we didn't like your answer, we'll do it again. That's what I read between the lines, you know. So how can we restore that confidence in people here as well, if when they do take part or engage, their answers are cast aside?
I think it's an awful thing that families have been put through on this. Hopes have been raised and then dashed in terms of dealing with the past for 2 decades now, really. We're going right back to certainly the first really serious effort to deal with it. Wasn't contained within the Good Friday Agreement. So other peace agreements in other parts of the world, you'll have an agreement, for example, to set up a truth commission or something like that as part of the negotiation. I think the people involved in the Good Friday Agreement negotiations thought it was complicated enough to get it all over the line without having a mechanism to deal with the past. What happened then was, as a result of that not being signed as part of the agreement, we had a piecemeal approach to the past, wee bits, you know, like the inquest system doing certain things, police investigations, various other things. Then we had the Eames-Bradley process, where again, families' hopes were raised, something's going to happen. That was established under a Labour government. You have a change of government then, the Tories come in, they don't implement that. And families' hopes have been, then you have the Stormont House Agreement, then you have the consultation, 2018-19, families' hopes raised every time. And then squandered. And for families who've been on the receiving end of violence during the conflict, to then go through that roller coaster of emotions, I think it's a disgrace, to be honest, Julieann. I think it's an absolute disgrace. I think it's a disgrace on our politics that this issue has not been resolved. And the reason it hasn't been resolved is a lack of political will, but also a lack of human empathy. I think the reality is, I think, that with this current Conservative government, they simply don't care about this part of the world. They simply don't care. I think that there is a lack of empathy. Louise is right, it's not a monolith, but the moral energy to get this over the line is clearly absent in the current government. And that can only be translated as a lack of empathy towards victims who live on this side of the pond. I mean, there is an empathy on the in Britain towards veterans That's true for British Army veterans who serve. One can see that in the politics around all of this. But I just think that there is just a lack of human empathy for people who have been put through the ringer for 2 decades on this, as well as having suffered during the conflict itself. There's just a lack of human empathy, and therefore that doesn't translate into the political energy to get this over the line.
Totally agree with you. And we're nobody's priority. I think Brexit also proves that. You know, we're almost like, you know, the one nobody talks about in the corner. So let's talk about the report that you guys worked on last year. So who wants to talk to me about the report? And basically it was a critical analysis of these proposals. Where did the report go? Who was it for? And what was the impact of it?
Okay, I'll summarize it and then my colleagues can jump in and out.
Thank you.
So what we did was there had been a range of options put forward to deal with the legacy of the conflict. A lot of these options had been driven by that political energy that I've just been talking about protecting British Army veterans. So there'd been a number of private member bills in Westminster around this issue. The Defence Select Committee had argued for, in effect, an amnesty for British soldiers, and the former Attorney General, John Larkin QC, had suggested an amnesty as well. So there are a lot of complicated, different mechanisms, a lot of which were driven primarily by this desire to deal with the veterans issue, to keep veterans out of prison. Our starting point on all of this was the Stormont House Agreement, implement the Stormont House Agreement, essentially. That was what was agreed. It was framed within binding legal obligations to have proper investigations of what happened during the conflict. So our starting point for all of this was that human rights compliance. And so we saw the Stormont House Agreement. It's not perfect by any manner of means, but it has the best chance to do an overarching approach to dealing with the past, and one that was human rights compliant. But in recognition of the broader politics, particularly in Britain, around the veterans issue and the pressure, what we tried to do was go through each of the options that had been put forward and benchmark them against human rights compliance, which is our big driver, against compliance with the Stormont House Agreement, and compliance with the Good Friday Agreement. So basically we went through all of these options and we drew out markers saying, this one won't work because of this is not human rights compliant, and so on and so forth. And where we ended up was by saying, okay, there's probably 3 ways of doing this that are workable. One is just implement the Stormont House Agreement, which is our preferred option. A second is implement the Stormont House Agreement, but address the issue of jail time. As you know, currently anyone who is convicted of a conflict-related offence will serve a maximum of 2 years if the offence took place after 73, and that's state and non-state actors. And so in doing the piece of work, we could see a route whereby the government already have the power to alter that 2-year maximum to 0. So what that would mean is that a person would be investigated by the independent, the Historical Investigations Unit, the mechanism that will be established under the Stormont House Agreement. If a determination was made that they would be prosecuted, they would be prosecuted, they have a trial. If they're found guilty, at the very end of that process, the government have the power, they already have this power, to reduce the 2-year max to 0. And so in one version of that, what we said was, well, look, you could make that reduction to 0 conditional upon them giving full disclosure of what happened, telling the truth at that stage. So if you think, for example, where someone who has denied their guilt right through the process, denied it in court and so forth, and then you have one last bite at the cherry, you've just been convicted, now tell the truth. And the families will get a report anyway out of the Stormont House Agreement mechanisms, but you could be contributing further truth to that family. So that was one way of doing it. And then the other way of doing it, the third workable option as far as we were concerned, was simply reducing the sentences to 0 with no conditionality for everyone. So you still have the investigation, the prosecution and so on, but you're saying, okay, we are now determining no one's going to go to jail, and those discussed. That's what we did. So we put that out. We launched the report in April of last year. A lot of work went into that piece of work. It took us 6 months to do it because it's complicated. And we put it out there at the same time, essentially, as COVID was hitting. And so it went out there. It probably didn't make a very big splash. And then we kind of engaged various people. You know, we sent it to all, of course, all of the stakeholders. And it, as some of your viewers maybe aware, it got a bit more attention there in November and December, following a presentation that we did on the research in Lambeth Palace at a meeting that was chaired by the Archbishop of Canterbury. So I don't know if my colleagues want to jump in, but that's the background to the piece of work that we were involved in, Julieann.
I mean, yeah.
Do you want to elaborate on that, Daniel?
Yeah, I suppose to think of the context of these different options coming forward, you had the Stormont House Agreement, you had a long period of foot dragging that we've already been through. But what did that coincide with? I mean, it coincided with, I mean, there's been decades of activism from victims' families to try and get the law applied, to try and get justice in particular cases, against sort of stiff resistance as well. But what it coincided with as the years dragged on were the first decisions that had come out of the justice system to prosecute a small number of soldiers. So you've now had, I think, 6 soldiers who've had decisions to prosecute. There have been higher numbers of decisions to prosecute Republicans and Loyalists for legacy offences in the same time. But you've had 6 decisions to prosecute soldiers. Whilst that's a small number, and whilst we are at the stage whereby not a single member of the security forces has ever been convicted since the Good Friday Agreement case.
Your volume's getting a bit down there.
From backbench story. Sorry, can you hear me now?
Yeah,
Yes.
fine now.
Yeah, I think we heard you up to say there's been no prosecutions of security forces.
Yeah, there's been no convictions of the security forces since the Good Friday Agreement, but the delay in implementing the Stormont House Agreement coincided with the first decisions to prosecute soldiers through the sort of ordinary criminal justice system. And there's been 6, which is there's obviously been more paramilitary decisions, but 6 decisions. And there was a very heavy backlash from sections of the British media, political and military establishment to that led to sort of cries that there was somehow a witch hunt against soldiers. Now, in our report, what we do is we examine in detail those claims, the claims of unfair treatment and the claims of that only soldiers are, for example, being subjected to legacy mechanisms. And we concluded in the report that those types of arguments lacked intellectual credibility whatsoever, simply contradicted by the facts. And there's a number of things that, first of all, there is no, the vast majority of cases that have been taken forward recently relate to Republicans and Loyalists rather than to the security forces. But if you look at the cases involving the security forces, you would actually expect a much, much higher proportion of the cases to relate to the security forces, for the simple reason that the rule of law during vast parts of the conflict was never applied to the security forces in the first place. So if you take the earliest, say the first 5 years of the conflict, 189 people were shot dead by the security forces, the vast majority by the British Army. In those years, there were 0 convictions of members of the security forces for those killings, 0. And in fact, until 74, there were no prosecutions. And indeed, the year before that, for the first years, there were actually no police investigations. So things weren't even properly investigated. There was some internal, I think, called tea and sandwiches process within the military itself, but that was presentational. It wasn't an investigation. So you've got a situation whereby, in theory, the rule of law applied to everyone, in the sense the law didn't exempt soldiers or anyone else from its reach, but in practice it didn't. And therefore you have a large number of cases that were never properly investigated, never properly dealt with. And you can add to that the way the levels of immunity that were afforded to agents of the state, of which we are getting more and more information in every level of the day. I mean, in court this week, in a case we're involved in, the UK government lawyers did say that MI5 could authorise murder as part of their policy. We're just getting more, and we know there were systems built into the RUC whereby detectives weren't actually allowed to to arrest and question suspects without special branches' permission, to stop informants being brought into the criminal justice system, and the way information was, say, withheld from prosecutors. So that there's a whole set of evidence as to how the rule of law was not applied equally during the actual conflict. So therefore you'd actually expect a much higher proportion. So that's the explanation, and essentially the argument against the Stormont House Agreement, and where the multitude of options had called for, had emerged for calling for amnesties, had come from that position of looking for an alternative whereby you could maintain a situation where soldiers and other members of the security forces aren't investigated properly at all.
Even in my own family, my uncle died on Bloody Sunday, and my mum always sort of thought they're waiting until we're all old or dying off, and there is a perception of that, you know, out there, that that they're going to just put everything on the long finger until everything's too late, and that includes trying to uphold the rule of law with soldiers. Some of the soldiers now are getting too old, and again that'll cause other reasons for delays in cases, in the very few cases we have. But I always find it very interesting when you're telling people about events here, and you say, you know, no, there's been 3,500 deaths, but six soldiers, isn't it, that have been brought up for their actions. So there is, of course, there's a dearth, and there, you know, the statistics speak for themselves there. And I think if people from outside the North see that, then say, oh, well, you might have a point, you know. So it's just trying to get people to maybe see that outside our own communities and our own society, that it's still very much prevalent, and it's still very important despite the passage of time. So Louise, what was your work on? Thank you for that, Daniel. It's really interesting. Louise, what was your work on the report? I know you're an expert on amnesties worldwide. So do they work?
I just wanted to follow up on something you were saying there, Julieann. You know, in the before times, before this COVID started, Kieran and I would have travelled a lot to other transitional societies, both to research those societies and sometimes to talk about Northern Ireland. And outside, I think there's always often a sense that Northern Ireland has been a success story. And of course, we have been in lots of ways. You know, we're very, very fortunate to have a peace process that's endured for as long as it has been. But I think there's also a perception of the United Kingdom as a rule of law state, a G7 state with all the resources and functioning institutions that should be able to get this stuff done. And so when we travel to other parts of the world where the levels of victims are much greater, much greater. I mean, going to Colombia and talking about Northern Ireland, when they're talking about 5 million victims, and they're making a good faith effort to try and address these needs. It puts the failure, the sustained failure over many decades here into a stark contrast. And so I do often find that very difficult to explain to international audiences about what hasn't been done here over a number of years. But turning to the report, my role in that report was really looking at, the most recent one was looking at the statute of limitations proposals. Because I have been looking at amnesties for a number of years, as you mentioned. Now, statutes of limitations usually are very different from amnesties. They are not designed to prevent prosecutions immediately. What they do is set a time limit and say, you know, after 5, 10, 20, 30 years, prosecutions won't be carried out. In most countries where they have statute of limitations, the UK, of course, doesn't have statute of limitations for criminal offences generally. In other countries where they do have them, they don't really apply to very serious offences like murder. So it'd be very anomalous for us to be doing that and to apply statute of limitations to serious crimes. What's also different about a statute of limitations, of course, is that it's meant to be a permanent and enduring part of a criminal justice system. You wouldn't necessarily just apply to conflicts in the past, but might apply to the actions of British service personnel going forwards. You know, so there could be lots of different ways in which statutes of limitations proposals are distinct from, but perhaps much more damaging than amnesties in their consequences. What is being proposed here in the statute of limitations has been very shifting, because as Kieran outlined really well, there's been so many proposals coming from different places. You know, John Larkin was just calling for a complete stay in prosecutions. The Defence Committee talked about statute limitations, and then after some pushback, they tried to be more precise about what they were looking for, and they talked about a qualified statute limitations. Now, that seemed to be that it would be something that wouldn't preclude investigations. The statute of limitations, from their understanding, would only be applied once an investigation had been carried out. And they said that if new evidence came to light, then the serious cases could still be reopened. But that raises a number of questions put into the backdrop of what Daniel has said about how investigations in the past are often very flawed. So, you know, if you're saying this case was investigated previously, has it been investigated enough to meet the standards required under Article 2 of the European Convention on Human Rights? And if it has not been, then no statute of limitations should be applied to it. It shouldn't be a bar to any sort of prosecution. And so that was a complicated one for us to analyse against the human rights standards, because there's a lot of ambiguity in what's being proposed. There's not a lot of detail in it yet. And so depending on how it's applied, it could impede prosecutions. It could close down the possibility of proper investigations. But if it's applied in a good faith effort, there could be space remaining for effective investigations, but that would remain to be seen. I think there's good reasons to be cautious about it at present.
I think one of the reasons here is a lack of evidence, isn't it? And a lot of the cases here, that because there was no initial police investigation, as was standard at the time, which again is unbelievable, that vital evidence and forensics weren't collected at the time. And so decades down the line, families don't really have much hope of getting this new evidence that would actually change things in family cases. So yeah,
I think that's right, Julieann, and I think that's why it's very important for those of us who work in this field not to overpromise, particularly around prosecutions. They're simply exactly for the reasons that you say, you know, the lack of available usable evidence that meets the required threshold to secure convictions. I think all of us need to be very careful about not overpromising victims. That there simply won't be large numbers of prosecutions for those reasons. It's just too difficult. You know, defendants, witnesses may be dead, memories are unreliable, and so forth. So it's actually quite difficult to secure convictions. However, I think one of the I'm often quite critical about the Stormont House Agreement. One of the positive things to come out of it is this idea about having an independent police investigation, which is not primarily aimed towards securing prosecutions. I mean, if the evidence threshold is met, then prosecutions may arise, but actually it's using all of the strengths of independent police investigations for a truth recovery or information recovery purposes. And that is something, it's sometimes we refer to it as truth recovery with teeth. You know, so that actually you've got the technical skills of proper investigations, but you also have powers. You have legal powers as the police. You know, you can search premises, you can seize documents, you have access to you know, 3 decades of intelligence files and all of that. And so taking all of that infrastructure, that policing infrastructure, and pointing it in a direction that is designed primarily to bring information to families, for us is a good idea. You know, that's actually quite, and it may help a lot of families, but we have to be careful by not saying it's going to result in a large number of prosecutions, because it simply isn't. But it's still worth doing, because it's worth doing for helping families to get more information about what happened. So in that mechanism, the historical investigation unit, the primary product to come out of it are reports that would go to families who were affected by the conflict, and those reports we know from the prior experience of the HET, the Historical Inquiries team, which did a similar piece of work, and the HIU is meant to take over from it, is that in the cases where the families received the better product, I mean, there are lots of misgivings expressed, as you may be aware, about what happened with the HET, but some families did get some good product out of that, and we know that the families who got a good report out of that, one of the key variables in that is, were those families supported by NGOs in asking the right questions. So NGOs, you know, like the Pet Friendly Centre, for example, or like CAJ, if families get the support to ask all the right questions, they get a better product out of it. And so there's quite a lot of learning that has come out of that experience, that we thought that, you know, when we take the skills and strengths that do exist in civil society in the North, that families could get something quite useful out of that. If you have a mechanism which is information recovery with teeth, and you support the families through that process, and you're not overselling the product of prosecutions, that you might actually get something quite worthwhile for those families. And then for us as a society more generally, part of the Stormont House Agreement mechanisms is that you take all of those individual bits of information that are produced by that mechanism and two other mechanisms which we may come on to, and then you pull them together to have to create a big picture narrative about. So you're not just talking about individual cases, but you're also looking at themes and patterns and what happened, you know, the causes and the consequences and the context of violence, and proper information recovery with teeth can provide us. So it's not just that the individual families will benefit from that. But one of the things that if we want to, as a society, ensure that we put in place mechanisms and structures and processes that make sure this never happens again in our society, then it's important for us to come to terms with that big picture as to what actually happened in this society, how did that happen, and what can we do to ensure it doesn't again.
Thank you, Kieran. It's a great answer. And how likely is it? How realistic is it that we're going to get anywhere with these processes? And how likely is it we're going to affect the people when they need it most now in the next 10, 20 years? You know, I'll open that up to the floor. What are you hopeful of? Are you hopeful of the goodwill winning? Because there doesn't look to be much goodwill. I think most of the effort would come from here. So, what's your thoughts on that?
I think I was thinking firstly when you were talking about the likelihood of prosecutions or, you know, new evidence coming to light through investigations. I agree with all that's been said about it's very difficult. It's well known in lots of societies. It's very difficult to do that sort of investigative work long after the violations took place. But that's not to say it's impossible. I think in the last few years, new evidence has come to light in different cases as documents have been disclosed. So we are still seeing that process. And I think through all our work on the model bill that we prepared a few years ago and the more recent reports, we were always hopeful that that as well alongside the historical investigations unit, which was the information recovery with teeth, there was proposed another mechanism for information recovery, which would allow for voluntary and confidential information to be provided by individuals. That could be individuals who are responsible for offences. It could be individuals who have knowledge of offences for other reasons. It could, you know, it could be any number of people. And we always felt that that had the potential to generate new information in Northern Ireland that is very important. And that's not to be a substitute for the information recovery with teeth. You know, that's one of the things that's worrying about the Secretary of State's statement in March last year, where he seemed to be moving away from the police-led prosecutions towards more information recovery, because we'd be concerned that information recovery alone wouldn't have the necessary teeth, wouldn't meet the requirements of Article 2 of the European Convention on Human Rights, etc. But the information recovery does have the potential to create an avenue for people to come and tell different things that they have knowledge about. And I think our understanding about the societies is that people do that. You're never going to get everybody who was involved in past offences to come and tell the truth. Some of them may not be around anymore. Some of them maybe just don't have the memories of it. But some people will always do that. I think in every place where amnesty has been offered in exchange for truth, the number of applications always exceeded expectations. And
so it has worked elsewhere.
Yes, although that's a different model to what's being proposed here.
Yes,
what's being proposed is an amnesty, so people aren't getting anything in exchange. But yes, in other instances where these processes have been set up, people have come forward and have taken part, and they have disclosed information that would not have been possible to obtain from other sources in ways which have, well, not being able to provide answers for all families, have helped some families understand better what happened in the past. And so I think it's important to go into those sort of conversations with expectations that there won't be complete answers on everything, but it might be useful for getting little bits of information about different things.
Excellent, thank you so much. And behind all this, I keep thinking about the families and the wounded and the people who, are they being listened to enough? You know, is there more politicians' voice and academics' voices and activist voices rather than the voices of the people who actually need help.
Yeah.
What's your thoughts on that?
I mean, there's a number of things there. I mean, obviously, a lot of the proposals that have been put forward and the ones we put forward are very victim-centred. Yet what was announced by the Secretary of State last March wasn't victim-centred at all. It was the opposite of what had been proposed. It was on the same day as the British government introduced what was called the Overseas Operations Bill into Westminster, and it was expressly stated that there was a change of course away from the Stormont House Agreement here to provide an equivalence to what was in the Overseas Operations Bill. And what's in the Overseas Operations Bill is a statute of limitations to prevent prosecutions for war crimes, including torture, including killings, including various other horrific things. And I mean, don't take my word for how bad this bill is. Take the line, and I'll read it out. The conclusion of the Westminster Parliament's own Joint Committee on Human Rights, it concluded, this legislation breaches the UK's international obligations and international humanitarian law, human rights law, and international criminal law, i.e. everything. So where does that leave the families of victims in Iraq, in Afghanistan, and in other parts of the world? And I think in terms of whether, yes, there's been a lot of bad faith recently from government, but the bottom line for this issue is it is not going to go away. It never does. It doesn't, it won't here, and it hasn't elsewhere. There are still truth recovery efforts going on, for example, in Spain, in relation to what happened between 1936 and beyond, with the Spanish Civil War and the subsequent dictatorship. You're talking many generations of people that have passed since then, but the battle for families, for truth, for information recovery, for justice, and that important third strand that's in sort of international human rights law and everything about this, which is termed non-recurrence. Like, the point of this is, yes, for past victims, but it's also to try and prevent future generations of victims by exposing the horrors of conflict, by exposing the elements of security policy that were outside the law and how they fueled conflict, with a view to them not happening again, even when those particular policies are still defended by elements of the sort of security establishment. To give you one obvious example, the use of torture. I mean, had the UK military been held to account for the use and development of things like the 5 techniques in Kenya and Aden and various other places before they were used here in the early 1970s, would they have been able to get away with it here? And would the impact of the use of torture, that was a huge driver in fueling conflict, have occurred had it not been able to be practiced? Had they been caught here at the time and held properly to account, would those same patterns and practices of use of torture have emerged in Iraq or Afghanistan subsequently? Or would they have been put beyond the pale by what had happened here and the level of accountability that had followed, had it followed? So this is very much about past victims, but also preventing future victims through the same things happening again.
I come in on that point, Julieann, as well, on the voice of victims. It's a very important point, and I think actually in our society we have a very well organised victims sector. We have over 50 victims groups in the jurisdiction, and I think one of the things, well, a couple of things in that. Number one, I think we have to respect the voices actually of victims, but respect them in their plurality and recognise they don't speak with one voice. And actually sometimes people's attitudes actually change over time, you know. So as you'll know, in Derry, and some people historically during the campaign around Bloody Sunday were focused primarily on truth. And then once the Savile inquiry happened and the truth came out, some people wanted prosecutions, others didn't. And I think that's fine. I think we have to respect voices, the plurality of victims' voices. As Daniel said, 17,000 responses came into the consultation on the Stormont House Agreement. And one of the things that Louise and I definitely would have picked up in other societies where we've been studying it is that what tends to happen actually is that sometimes politicians hide behind and amplify particular voices of particular victims because they agree with them politically. And they also try to silence other victims who take a different view. And so where dealing with the past actually works is where you listen to the plurality of voices and respect including victims' voices, but not just victims' voices, the plurality of, because we all have a stake in this, listen to and respect them in their plurality. And then you take a decision, okay, we can build a workable consensus around this, and the Stormont House Agreement was that workable consensus, is that workable consensus. Not everyone is going to be happy about it, but it's lawful. So you benchmark it against international human rights standards, and you get on with it, basically, as a political, as a state or as a set of political actors, and you do not continuously hide behind particular victims' voices because it provides a rationale to do nothing. So you advocate for something, for example, which you know is never going to get delivered because it resonates well with X percentage of the victim sector, and you know that sector over there are going to be very happy, and they may only represent 10%, 15% of victims or whatever, but they're the ones that play well. It's like Trump politics plays well with the base, so you know that this line will play well with that base. Now that's fine. In politics, all politicians have to look after their base, but it's not a way of actually taking ownership and responsibility and moving on. So I think we've had a lot of consultation and discussion and involvement and engagement with victims and other stakeholders for the last 20 years, and that's right and proper, but we have to get on with it. And that's that's the challenge. Is victim's voice can give you a place to hide politically. Yeah. We've moved past that. We've had our consultation. Get on with it.
It sort of ties in with why my next question was about what's the generational impact. Is there a sense of duty to the next generation that this has to be sorted out now? That we're not going to leave this cauldron of problems for the next generation to sort out. That's what I always thought growing up, that was what my aunts and uncles were doing on behalf of our family. But now I'm the same age as they were when they started, and how far further have they got? My family got more than most, but they didn't get any justice as such. They got truth, a bit of truth. So what is the duty to the next generation to keep at this? Yep, Louise, I'll open that to you.
So I was going to come back a little bit first on the previous point about victims' voices. And I agree with everything that was said. Recognizing the multiplicity of voices. We're never, and this is a common issue to most post-conflict societies, that victims speak from different perspectives and have complicated identities that bring all sorts of factors to how they view legacy questions over time. But I think it's important that they do have a platform to speak. And I think looking now, trying to achieve a consensus shouldn't stop us going forwards. It's going to have to recognize, everybody has to recognize that this is a process of negotiation, that things are never going to be quite perfect, but they can try and find things that we can all coalesce around. But what I'm interested in going forwards is how do the legacy institutions, if they are established, continue to listen to victims' voices? And then that's something that we've been talking about in our various proposals. So proposing for the Oral History Archive or the Independent Commission on Information Retrieval, we're writing into that this engagement with victims needs to be part of the functions of these institutions. So it's not just consultation now when we're setting out the broad architecture, but it's got to be something which is sustained over time. And that's recognizing all victims across our society, I think. But turning to our obligation to future generations, I completely agree. I think around the world, we can see that, as Daniel rightly pointed out, this does not go away. It's not possible to put this in a long finger and hope it disappears over time. That strategy doesn't work. And generations of families will keep seeking answers for their mothers, for their grandmothers. And what we understand increasingly is that failure to do that passes on psychological harm to other generations. I was reading studies recently where they found that trauma becomes encoded in the DNA of victims and leads to higher rates of depression that is then passed on to other members of their families. There's lots of ways in which people inherit this baggage that we have to grapple with. But I think beyond that, beyond the needs of individual victims, which should be central to our concerns, we also should think about what does this mean for our culture, our society, our political life. The failure to deal with these issues continually is corrosive. I think with some of the problems we see at Stormont about how our parties come together or don't around fundamental issues like the coronavirus, I think get tied to this dysfunction in our society that we need to grapple with if we want to move on.
I think it would put a lot of young people off even thinking about politics, seeing the way politics is here, So what else can we talk about here?
Can I just come in on that point on the
Oh yes, please do,
intergenerational
Kieran.
point?
Yeah,
Yeah.
yeah. I've
I mean,
lost
one
my
of the
way there because I was too
one of-
busy listening.
No, it's okay. I mean, one of the just to pick up on Louise's point there, one of the interesting things for me as well, I mean, I have to be honest, when I came to this, I think I started working on dealing with the past here at home in 2004, so I've been battering away at it for a while. And I was pretty agnostic about whether or not we should actually have a mechanism or mechanisms for dealing with the past. You know, I was more sympathetic maybe in those days to the argument about let's just move on. I've changed completely since that, primarily because of the reasons that Daniel and Louise have articulated, you know, that you can't, until you sort it out, it's just going to poison your politics. But one of the things that, one of the additional reasons why you have to deal with the past is because if you allow the space for lies and myths to permeate your politics and to be passed on to the next generation, you leave the space open for violence entrepreneurs to step in there and radicalize another generation of young people to go back to conflict. Unless you've had a proper warts and all approach to dealing with the past and the reality of the horror of violence that people of my generation lived through and how horrible that was, you leave space for what Michael Ignatieff talks about as permissible lies, you know, lies that permeate politics and are passed on between generations and within communities, you know, that it was all them and that did it and that we had no responsibility, you know. You create notions of false innocence, you know, and unless you have a process where we all come to terms with our responsibilities as different sectors within society, and what we did or didn't do during the conflict. And I don't just mean the people who were directly involved in violence, but actually even social structures, political structures, the churches, you know, in the South African process, for example, in the Truth and Reconciliation process, they had hearings, institutional hearings about the role of the judiciary, the role of lawyers, the role that universities played in the apartheid process. Churches, you know, so thinking as a society, how did we get to the stage where we thought, elements of us thought, that it was okay to kill the other? Like, what happened in our politics that was, you know, people who got involved in violence didn't land from Mars. And so something went wrong in our politics. And unless we address that as a society, we run the risk that future generations will think that it's okay to become re-involved in armed struggle, that it's okay to use violence as a way of dealing with our political problems. So there's a kind of compelling, so I've shifted personally on it over the years of working on it, where there's just a compelling moral reason to do this. And it's precisely your point, Julieann. It's about the next generations as well as those of us who are older.
I totally agree. I also think it's about setting a good example, you know, in its business terms, setting a good example. That's the way I would explain it to my 11-year-old. You know, you have to let people know that this is not acceptable, this is what we expect, and this is what should be expected, you know. So in light of Brandon Lewis's absolute disregard for anything that happens here, do you think he's the man for the job? Sorry if that sounded a bit callous, but
Daniel, do you want to pick that one up?
I think it's pretty evident from what we've already said what our views would be on that. I mean, there are obligations on the Secretary of State to comply with the law. And if he's not prepared to do that, then someone else should do it. It's, I mean, there are international legal obligations to investigate what happened in the past, and they need to be discharged regardless of who the Secretary of State is. We cannot break international law in more than a specific and limited way, which was his famous phrase over the one of the Brexit bills. I mean, there are huge sets of obligations here that aren't being complied with, and they need to be regardless of whether it's done by Brandon Lewis or someone else.
Picking up on Louise's point earlier,
just to pick up on the broader stuff.
Sorry, Daniel. Sorry.
No, good. No, just not to deal with this is going to cement a really poisoned legacy across communities, and it poisons even things like the policing of the present, because it then gets tainted with issues of the policing of the past and can't move on, can't be separated, which was the idea of the Stormont House Agreement, to completely remove the issue of legacy from policing of the present, and that taking place. So it ain't going to go away, and it really needs dealt with.
No, I mean, shifting away from the individual and Brandon Lewis's reckless indifference to us and what happens here. I mean, I fluctuate on this sometimes, but Louise is right earlier what she said about the state not being a monolith, and it's true, the state isn't a monolith, and actually the Tory party isn't a monolith as well. And on better days when I'm feeling a bit more chippy, I still hold out the view that if people can tilt the axis and reach sensible bits of the British government and even sensible bits of the Tory party, if you say to them, listen, this Stormont House Agreement is what people agreed, and we agreed to it, and we signed a treaty with the Irish, right? So that's the starting base for everything. There are workable solutions. Your big issue is keeping veterans out of jail. That's kind of all elements of your party care about. There are even ways of doing that, which will be difficult and unpalatable for many victims, but there are ways of doing that and implementing the Stormont House Agreement that we've already agreed to and upholding the rule of law. Why would you take a wrecking ball to it otherwise? I mean, on something that's not going to work. Why would you, for example, go down the route of introducing an amnesty which is opposed across the political spectrum in Northern Ireland, which would inevitably apply to both state and non-state actors? So they won't be able to introduce an amnesty and that only applies to state actors. Inevitably, the non-state actors will also benefit from that. Why? And this is me kind of appealing to an imagined sensible Tory out there. Why would you take a wrecking ball to all of that? I'm picturing an imagined sensible Tory, and I've met some and they do exist. Why would you take a wrecking ball to that when there's a more sane and sensible route through all of this? So on better days, I think, whatever about the personality of the Secretary of State, reaching out to imagined sensible bits of the British state and sensible bits of the Tory party, there are sensible ways that they're doing this that can achieve your objectives, uphold the rule of law, and implement what you've already agreed to, and actually finally deliver something for victims who've been waiting for far too long.
Sorry, Louise, are you looking to speak there?
Yeah, I was just going to follow up on what Kieran was saying. I think all those domestic reasons for not doing this are fundamentally important, but I guess my own research on amnesty laws around the world looks at when countries introduce amnesty laws, what type of scenarios. And I have found that in post-conflict societies, there are no democratic states that have considered trying to block prosecutions 20 years into a conflict to benefit state actors. You know, there are a couple, where amnesties are used post-conflict, they are designed to further a peace process, to try and bring people together. They often apply to all sides anyway, but Britain would really be out on its own in the international stage if it, as a democratic state, it does this. So I think that is not a great look for the UK as it's starting out in its new global adventure post-Brexit. So I think there's lots of things that they should be weighing on in their minds when they're thinking about this.
Would you agree with, would you think that, hold on, I've lost my question. Where are we? Has there not already been an amnesty of sorts here for about 40 years? It's not really a question. It was more of a statement. You know, it feels almost like there's been an amnesty of sorts only for the security forces. But again, it's not all about them. But it's just that it keeps coming back to them, and we can't really escape that.
I mean, any of us could do this one, but there has been absolutely a culture of de facto impunity, as Daniel said earlier. I mean, you only had during the conflict 4 British soldiers convicted of murder, and you know, you had over 350 people killed by the state, majority of them who were unarmed civilians, and so people were not held accountable during the conflict. You had 35,000 of Republicans and loyalists who went to prison, and so that, you know, one of the actors, one of the 3 actors, the state actors, were not held accountable during the conflict, and they haven't been held accountable during the transition. And we part of, as Daniel said earlier, part of the driver for all of this is that what's happening now is that you're having a small number of British soldiers prosecuted for historical events, and we can see the effect that that small number of soldiers, they're not going to serve any longer than 2 years. In my own view, personally, I don't think any of them will serve a day. I do not think that this UK government will allow any British soldier to do a day in jail. So I think that's just a political reality, given based on historical analysis of what went on in the past. I mean, during the conflict, you had people released after 3 or 4 years, serving a life sentence. Some of them being paid while they were still in prison, having been convicted of murder and then returned to the regiments that they'd left and promoted. Like that's in your face impunity. Like that is, it does exactly what it says on the tin, you know, and that was what was happening then. These are now elderly veterans. Like, so my own view is they will not allow any of them to do a day in jail, and they already have the power, as I said, to reduce that. So we've had a culture of impunity for state actors. That's absolutely true. But we are where we are, and we are all collectively trying to nudge this along in a rule of law and human rights compliant fashion, where victims get the truth at least and some form of accountability that they richly deserve.
Brilliant. Thank you. Thank you. Yep.
Can I just come in there, Julieann, and like what for me the difference is often between the de facto impunity that Kieran's just described and an actual amnesty law. You know, we're in contexts where amnesty laws are introduced. There are legal measures. They set out that crimes have been committed and that these crimes need to get an amnesty. So there's an element of acknowledgement, putting things on the record if you grant an amnesty law. Often amnesties have particular conditions. You are, by granting someone an amnesty, you're making them apply to get the amnesty. They'll have to disclose something as part of the application. It can be more, you know, it could be towards a full truth recovery thing, it can be something less, but they're having to tell something about their actions. They're often having to submit to particular conditions on their behaviour, to refrain from certain activities, for example, to commit to upholding the rule of law. There can be any number of conditions in different societies. So while the situation we have at the moment of de facto impunity hasn't led to a law that bars prosecutions, it's led to what we have in the absence of that is any acknowledgement of many of the crimes that took place and a process by which people are at least processed in some way, that there's conditions imposed on them, even if it's not prosecution. So what we have is very different, I think, from what an amnesty law could look like.
I think sorry, I was just going to say that the idea of acknowledgement comes up time and time again in any of the work I do too, and it's such the layman is such a simple thing, an acknowledgement, but the people who need it, it could be everything, you know. I just wanted to ask, in your view, all of you, is it a binary choice between prosecutions and amnesty, or, you know, is there
no, it's not. And I mean, that was in the Stormont House was a compromise, but it was a mixture of institutions that did that. So you had the independent police unit that Kieran described, the HIU, as it would have been. It would have done independent police investigations and would have produced family reports, but using all the police powers to compel evidence and information, it would have led to probably a very small number of prosecutions. And the remedy for most families would have been the family report that set out all the information that was known about the death of the loved one. You had the Independent Commission for Information Retrieval. It was one of those bodies where you can go and make statements that have a level of immunity attached to them, and it's very much a truth recovery mechanism. We had the Oral History Archive that was mentioned earlier on, as well as then a sort of a unit that was meant to try and tie this sort of things and pattern stuff together. So it was a mix of institutions, that it wasn't all just about using criminal justice mechanisms. And I think just to reflect back on the last discussion, sometimes we complicate this discussion. We had the Stormont House Agreement there as a potential model, and there's been resistance to it, and sometimes we overcomplicate what that resistance to, but it's very clear, as everyone has said, and as you set out, there was de facto immunity for the security forces most of the time during the conflict. And what the alternatives to the Stormont House Agreement usually are about is keeping that de facto immunity, but it is with a very important difference, and in some sense it does show one success of the peace process, because in the past what you had was a situation whereby the law in theory did apply to the security forces, but there was effectively, the way the criminal justice system was set up, there was a reasonable guarantee that it usually wouldn't be applied, that police wouldn't properly investigate such cases, prosecutors wouldn't prosecute, or on the few occasions that they did, you'd get judges that would make perverse verdicts and let people off who should have been convicted. And I think what at least this does show us over reasonable years is certainly those calling for an amnesty to be written into law realise that there has been a sufficient level of reform of the criminal justice system here that can no longer rely on it not to apply the rule of law to the security forces, and therefore they're seeking a legal route to prevent that from happening. And that's I suppose the nub of what's happening. It's not complicated. It's pretty clear what's going on.
Very good, thank you, thank you. So where do we go from here? I know there's absolutely no way that you would be able to tell me, but how long are we going to have to wait? You know, in your gut, are you thinking, and this is what all three of you in your gut, do you thinking this is going to be sorted out in 5 years, it's going to be sorted out in 10 years, or you know?
I think that the cases that are before the courts at the moment involving soldiers, that's the ticking clock. And so I think that that's where the political pressure will be driven by the time frame by which those cases are processed. I suspect that within the Northern Ireland office, there's been a recognition that the amnesty statute of limitations is not going to work, and that there's no appetite for it here, and that it would apply to the non-state actors. So the clock is ticking really with those cases. And so, I don't think we're going to have to wait 5 years. I think as those cases come through, I think that's going to focus their attention to what are we going to do here. So the clock is ticking.
Excellent. Anyone else got an answer for that?
I guess just to add that, you know, while we might have, we have to wait for the process to be set the legislation. Once that happens, or if that happens, then there will be further delays in terms of setting up the institutions. It may take a year, it may take 18 months after a law is passed to actually have institutions in place. And then it's expected that their work will carry on for many years. So if in the best case scenario, we get legislation on this in the next 12 months, I think it's been clear again with families that this might take a while thereafter to get to a position where cases could be heard. And if there's delays getting to legislation still, then that pushes that further into the distance.
I think families have long since given up waiting for things, you know, actually checking their calendar, waiting for things, because a month becomes a year, and it has become decades and 50 years in some cases, which is just terrible for people out there. So we'll try and tie it up with the last question. What can we do to help? You know, what can the population do to help? Is there anything we can do to try and further things here, and to try, you know, what can we do to make things better?
I think keep the pressure on our political representatives to get this over the line, essentially. I mean, our local political representatives, I think just keep the pressure on, essentially, that legacy needs to be dealt with, and the consequence of it for individual families, but also for the stability of our politics. It's just, we have a political and a moral imperative to get on with this. So I suppose my advice would be for people not to give up and to keep the pressure on, because it's going to have to be dealt with.
Totally. Anybody else on that?
I completely agree with that. You know.
Yeah, me too. Just we're all going to have to keep at it, and I think even if we do get some progress on the big picture on this, there are going to be so many micro battles to follow. And
I suppose all of us can draw inspiration from the Bloody Sunday families themselves. I mean, there would have been, you'll think how long that campaign went on. There would have been periods where people, I'm sure, thought we're never going to get anywhere with this, and yet they did. And I think they remain an inspiration, I think, to other campaigning families. The fact that you just keep doggedly at it, you keep mobilizing, you keep strategizing, you use law if you can, you just keep at it. So I suppose that's, if there's an uplifting way to finish it, the inspiration of the Bloody Sunday families themselves is, you know, you just keep plugging away at it.
Just don't give up. Perseverance is key. Yeah. Well, on that note, that's a good ending. So thank you all so much for taking part today. It was a fascinating talk. And thank you to the Pat Finucane Centre for inviting me to chair it, and thanks to the museum for hosting it, and thanks to all of you, my guests, and to Kira in the background somewhere who's organising the Zoom. And just a reminder to anyone at home, if you could remember, and if you wanted to light a candle at 4:10 tomorrow, Saturday, the 30th of January, and it's to remember the dead and injured of Bloody Sunday and anyone else that are died or is affected by the conflict. So 4:10 tomorrow, light a candle in your window. Okay. And thank you so much for everything, everyone, and goodbye to everybody at home. Thanks for listening.
Thanks for having us, Julieann.
Thanks, Julieann.
Bye. Bye.